members of the judiciary, friends of the law school, ladies and gentlemen. My name is Niamh Howlin and I'm the Dean of Law, and it's a great pleasure for me to welcome you all here this evening on behalf of my colleagues for the 2022 John Maurice Kelly Memorial Lecture. It's a real pleasure to see so many familiar faces back in our building after so long, and it's also lovely to meet some new people and see some new faces this evening too. This lecture series honours the memory of John Maurice Kelly. He studied in UCD, in Heidelberg, Oxford and the King's Inns. He was a lecturer and a fellow at Trinity College, Oxford, and a professor of Roman law and jurisprudence at UCD from 1965. He edited The Irish Jurist and published several seminal texts which are well known to most of us, including Fundamental Rights in Irish Law in 1968 and the Irish Constitution, which is now in its 5th edition. Alongside his academic career, John Kelly was also very active in politics, having served as a senator, a TD, a government minister, and as Attorney General. He retired from politics in 1989 and then sadly passed away in 1991, aged just 59 years. I'm really pleased to welcome some members of the Kelly family here this evening as well. So without further delay, I'm now going to call on the Chief Justice to introduce this evening's distinguished speaker. Chief Justice.
Yeah. Thank you, Dr. Howlin. As Chief Justice, it turns out that one of my functions is to chair a bewildering number of boards, committees and groups. At last count, I think it is totals 32. However, I am not required to chair the J.M. Kelly Lecture Committee. That is a pleasure. It's something I'm glad to do. Firstly, to honour the memory of the man, but secondly, because he is being memorialised in the form of a classic public lecture. And introducing tonight's lecture and lecturer, I would like to say something briefly about the man, the lecture series, and this evening's lecturer, and perhaps draw some threads together. It's a sobering thought for me that for any lawyer and law graduate of this university under the age of 50, John Maurice Kelly is a name on the spine of a very large book, and lawyers under that age will have had no direct experience of the brilliant lawyer and law teacher that he was. He had a remarkable academic career, as Niamh said, leaving a fellowship in Oxford at an early age to become a professor of Roman law and jurisprudence and Dean of the Faculty of Law in this university, which is at that time, a rather grand title for what was then one room in Earlsfort Terrace. He single-handedly revived the Irish Jurist, turned it into a high-quality legal publication. He published 3 major works of Roman law, an important work in jurisprudence, 2 of the most early and brilliant books about the Irish Constitution, and of course, the first 2 editions of the landmark text itself, the Irish Constitution, a task that has been carried on so faithfully into the 5th edition by my friend and colleague Gerard Hogan, who is here tonight, Professor Jerry White, and David Kenny and Rachel Walsh of Trinity College. In all of this, he had the very rare and enviable gift, shared, I think, with tonight's speaker, of lucid, indeed pellucid, crisp and vivid expression. There are very few people who can combine the capacity for original thought with striking prose style. He was a brilliant teacher, not in the crowd-pleasing, student-entertaining way, but in fact in a rather distant manner. He came into a lecture theatre, delivered his lecture and left, but always leaving students more informed, stimulated and educated than they had been only 50 minutes earlier. But what was remarkable is, as Niamh said, that he combined what was by any standards a stellar academic career with a parallel life as an active and successful politician, elected first to the Shannon in 1969 and then to the Dáil in 1973, and holding from the first day of his election both junior and then senior ministerial office. It is worth recalling, however, that he was not by any means universally popular either in politics or in academic life. He was, by the standards of the 1970s, uncool and is seen as something somewhat old-fashioned. It was only gradually that it came to be realized that what appeared to be old-fashioned was really timeless and invaluable, a commitment to intellectual honesty, whatever the tide of popular or academic opinion, and a belief in the importance of debate, discussion, and clear expression. When he died in 1991 at the early age of 59, this university set up this lecture series in his honor, and it was a measure of both his reputation and the affection in which he was held that it initially attracted a very distinguished list of speakers with a bias towards public law topics and often the lecturer is drawn from his old university friends and colleagues in Oxford. Now, a public lecture might appear an anachronism today and a somewhat old-fashioned in an era of TED Talks, YouTube and Instagram stories. It's probably fair to say, a somewhat inefficient vehicle for what it is meant to deliver. That is original and sometimes sophisticated thought and precise analysis, all delivered orally to a mixed audience. Tonight's lecture was meant to be delivered in 2020. The intervening 2 years have surely proved to us, however, the real benefits of getting together in person, hearing a speaker in real time, and discussing matters afterwards. More recently, again, events in the Ukraine have overshadowed everything we do. But I cannot help being struck by the way in which control of thought, discussion, information, and debate has been a vital part of the machinery of invasion. One consequence it should be to make us value freedoms in the Western world, which we have tended to take for granted, and to realize that those values depend fundamentally on freedom of thought, conscience, and expression, and the free exchange of ideas. Those are vital values that a university should promote. No more than John Kelly, the process of the public lecture in an educational institution is not old-fashioned. It is, in truth, timeless. This brings me to this evening's speaker. In an age of Wikipedia, it's probably true to say that no speaker, in truth, needs much introduction, and it's perhaps fair to say that tonight's speaker needs even less introduction than when this lecture was originally scheduled in 2020. But there are some points worth noting in the present context. Jonathan Sumption qualified as a historian and taught and wrote history at a high level until 1975, when he pursued a career in the law to, as he put it, increase his budget for groceries, in which I understand he had some modest success, and became a much sought after and very successful counsel practicing in the field of commercial law. In 2012, he was, of course, appointed direct from the bar to the Supreme Court. I think he was the only person so appointed in the modern era, and the 6th person in the history of the UK's final Court of Appeal to be so promoted. On the Supreme Court, he has written a number of landmark judgments, some of which have shone new light into areas of private law, and in particular issues of contract, but also important and perceptive judgments in the field of public law. All of the judgments are distinguished by forceful analysis and a style that combines precision of thought with an enviable clarity of expression. But just like John Kelly, what is perhaps extraordinary is that while continuing to practice as a lawyer in a demanding area of law, he continued his career as a distinguished historian, producing, amongst other things, so far, 4 volumes of a history of the 100 Years' War, which have met with broad critical acclaim. In addition to all of this, he has delivered a series of speeches and lectures on a formidable range of topics, exhibiting a decidedly independent mind. As it happens, John Kelly's 2nd edition of his book, Fundamental Rights, contains an early and perceptive consideration of the impact on the political and governmental systems more generally of the developments in constitutional law, which began with the case in this jurisdiction of Ryan and the Attorney General. Lord Sumption, for his part, delivered an important lecture on the limits of the law, touching on similar themes, which led to a symposium and the publication of a book under that title, containing both his essay and a number of responses, all touching on similar themes. After his retirement from the Supreme Court, he delivered the Reith Lectures on the BBC, which have now been published in a book form under the title Trials of the State and the Decline of Politics. Those lectures achieved something quite remarkable. They are stimulating and thought-provoking to read and reflect upon when encountered in written form. But they were equally, if not more impressive to hear delivered orally, as they were intended to be. And they contain a fascinating analysis of some difficult concepts delivered to a general audience. More recently, a series of speeches and lectures have been published under the title Law in a Time of Crisis, and some of which indeed have provoked some controversy. And in the world of dramatic arts, we are now coming into awards season, and Lord Sumption is a runaway favourite for the award entitled I'm Not Always Sure I Agree, but I admire his willingness to say these things and envy the facility with which they are said. I'm not sure either that John Kelly and Lord Sumption would always have agreed, but I am sure I would have paid good money to hear them disagree. Tonight's lecture addresses an issue of continuing importance to every jurisdiction in the European Union and will, I am sure, stimulate, inform, and ultimately educate us all.
Thank you, Chief Justice, for those flattering and undeserved words. The question is this: what happens when an irresistible force collides with an immovable object? Physicists evade that question by saying that there are no such things as irresistible forces or immovable objects. But lawyers, apart from the fact that they like to refresh the parts that scientists can't reach, can't evade it, because there are issues which arise on two fundamental but mutually inconsistent premises. In this lecture, I want to consider one of the more notable examples. The irresistible force is the primacy of European law in the legal order of member states of the Union. The immovable object is the body of domestic constitutional law which determines the limits of what a member state can do or the propositions which its law can accept. In October of last year, Poland's Constitutional Court ruled that its constitution prevailed over European law. The background to this decision was the dispute over the independence of the Polish judiciary, which has been rumbling on ever since the Law and Justice Party won power in the elections of 2015. The European Commission instituted proceedings against Poland on the principal ground that changes made by the Law and Justice Party to the appointment and retirement of judges undermined the independence of the judiciary and discriminated against women. In 2019, the European Court upheld the Commission's complaint. The Polish Constitutional Court, now composed entirely of nominees of the Law and Justice Party, held that the European Court of Justice had exceeded its competence under the EU treaties by purporting to rule on the constitutionality of judicial appointments. That, it was held, was exclusively a matter for Poland and depended on its internal constitutional order. There is a somewhat broader dispute with Hungary, which arises from the efforts of Mr. Viktor Orbán's government to transform Hungary into a one-party state in which a large parliamentary majority is used to ensure that all levers of power and influence are pulled by the Fidesz party. More recently, the temperature has risen as a result of the decision of the European Court on the 16th of February of this year, authorizing the Commission to withhold convergence funds from Poland and Hungary on the ground that they had departed from the founding values of the European Union. There is a procedure under Article 7 for suspending members' rights if they depart from those values, but the Commission was understandably unwilling to use that because it would have required a unanimous decision of the other member states and would have been vetoed by Hungary. So instead, they relied upon a principle that departure from the rule of law imperiled the proper expenditure of EU funds because there would be no authority that was capable of enforcing it. Now, a somewhat similar issue has arisen quite recently in Romania. On the 21st of December of last year, the Court of Justice of the European Union handed down a judgment on a reference from the High Court of Romania. The High Court of Romania had convicted a number of prominent Romanian politicians of corruption. The Constitutional Court of Romania had quashed the conviction on the ground that the High Court had been improperly constituted. Panels in the High Court are selected for assignment to particular cases by lot, but it appears that one of the 5 judges sitting on that case had not been selected in that way. The European Court of Justice ruled that the decision of the Constitutional Court had been contrary to the rule of law. First, because it undermined attempts to suppress corruption in Romania, some of which affected the expenditure of EU funds. Secondly, because the failure to constitute the panel by lot did not affect the judicial character of the decision. And thirdly, because the decision infringed the principle of judicial independence. The response of the Constitutional Court of Romania followed just 2 days later, on the 23rd of December. It took the unusual form of a press release of uncertain legal status, criticizing the reasoning of the Luxembourg court and declaring that it would not be lawful in Romania to comply with it without a constitutional amendment. Now, I am not in this lecture concerned with the legal or political merits of what these three governments have done. My concern is with the wider juridical implications of this dispute, and in particular, the relationship of EU law and national constitutions. The issue can, I think, be stated in this way. When a state becomes a member of the European Union, it transfers part of its legislative and judicial sovereignty to the European Union. On the face of it, the principle of conferral means that the powers of the EU's institutions depend on the extent of the transfer. As a matter of international law, the transfer is effected by EU treaties, of which the European Court of Justice is the ultimate and decisive interpreter. But as a matter of the domestic law of member states, the transfer is effected under national law. This may happen either because the constitution of a signatory state gives automatic and overriding effect to the treaties as part of its domestic law, as the current constitution of Ireland does, or else because ordinary legislation is enacted to give effect to the transfer of power. In either case, the reception of treaty law into the domestic legal order of a member state depends on its domestic law, whose interpretation is exclusively a matter for national courts. So what if EU law, as interpreted by the European Court of Justice, and national law, as interpreted by its highest domestic constitutional court, arrive at inconsistent conclusions? That is, the collision between the irresistible force and the immovable object. Now, this issue has emerged with special intensity in the countries of Eastern Europe, but it is not peculiar to them, nor is it just a dry question of legal analysis. It raises some of the most profound questions which any political community can ask about itself. What is the basic building block of the international order? What is the ultimate source of political and legal authority in the societies in which we live? What are the defining characteristics of the state, and does the European Union possess those characteristics? If we have multiple identities, as most of us do, which is the dominant one when they point in different directions? Now, these are very fundamental questions with implications that extend far beyond the European Union. The two founding doctrines of the European Union are the principle of conferral, i.e., that European institutions only enjoy the competence conferred on them by member states by treaty, and the primacy of European law in the legal order of member states. Neither of these principles was set out in terms in the original treaties, which created the European Economic Community, as it was then known. But they were probably implicit from the outset, and they were endorsed in successive judgments of the European Court of Justice. They are an essential part of the architecture of the European Union. This is because, in the absence so far of a common European identity or common political European values, the European Union is neither more nor less than a body of common rules. Without those rules, the Union cannot in any meaningful sense exist. The European Commission can afford to lose on the question whether Poland and Hungary have departed from the rule of law. but it cannot afford to lose on the question whose law prevails. The answer given by the European Court of Justice has been consistent throughout. It was stated in two famous cases decided in the 1960s, Van Gent and Loos in 1963 and Costa and Enel in 1964. Van Gent and Loos is, of course, the leading authority for the doctrine of direct effect. The arguments exchanged are quite interesting. The Dutch government contended that the EC treaties, like any other treaties, were binding in international law as between the EEC and each member state, but had no direct impact on the rights and obligations of citizens as a matter of domestic law. In rejecting this contention, the Luxembourg court acknowledged that that would ordinarily have been the effect of a multilateral treaty between states. But they made the radical claim that the founding treaty of the EEC was more than an agreement which creates mutual obligations between contracting states. They created a new legal order which superseded the legislative autonomy of member states in the areas within the competence of the EEC. Costa and Enel, which followed a year later, was an even more radical assertion of the existence of a new legal order. The treaty constituting the European Economic Community was incorporated into Italian law by a specially enacted statute of 1957. The issue in the case was whether an Italian law of 1962 nationalizing the electricity industry was compatible with the treaty. In a parallel case, the Italian Constitutional Court had held that the extent to which EEC treaties were received into Italian domestic law was on the face of it a question of Italian law for Italian courts to decide. The Italian statute of 1957, which had received European law into its domestic legal order, could be repealed or amended by subsequent legislation, just like any other Italian statute. Therefore, it was said, if the statutory nationalization of the electricity industry was incompatible with EU law, well then, the incorporation of EU law into the domestic law of Italy must to that extent be regarded as having been modified. The response of the European Court of Justice was to say that the treaty represented a higher order of law, displacing Italian legislative sovereignty. It couldn't, therefore, be either repealed or amended by Italian domestic law. Now, these decisions laid down three principles. First, it's for EU law to decide which system of law should answer the question of primacy. Secondly, the question of primacy must be answered by reference to EU law. Thirdly, by EU law wins. Now, in substance, they were saying that the treaty was not simply decisive on the plane of international law, it was itself a constitutional act by which, in areas within the EU's competence, a member state's legal and political identity is subsumed in a larger entity. But in its judgment in the Romanian case, which I've just cited, the Court of Justice restated these principles. In sum, they said, the treaties constituting the European Union were what they called, I quote, a constitutional charter, unquote, for the community and each one of its member states. Now, the problems posed by this analysis can, I think, best be illustrated by a glance at the best known historical example of a union superseding in limited areas the autonomy of its component parts. The example is the United States of America. The Constitution of the United States declares itself to be the supreme law of the land. By acceding to it, the component states of the Union agree that the Constitution is to supersede their own constitutions and their own substantive laws so far as they conflict. There are, however, significant differences between the United States and the European Union. In the first place, the European Union is not a state, but an international organization whose members pool their sovereignty in certain areas. Secondly, the states of the United States had a far higher degree of cultural and political homogeneity in the late 18th century than the nations of Europe had in the 20th. Thirdly, the United States is not dependent on the states for the application of federal law. It controls the reserve of force, which is the ultimate basis of all political and legislative authority. The president is the supreme commander, not just of the armed forces of the Union, but also of the state militias when they are called upon. This was graphically illustrated when federal marshals were brought in to enforce effectively, militarily, the decision of the Supreme Court in Brown and the Board of Education about the integration of schools in the southern states of America. Now, the United States is perhaps the most striking historical example of a new legal order displacing in defined areas the sovereignty of its constituent parts. But it did depend on those three factors which distinguish it from the European Union. The issue was dramatically tested in the Civil War, when the Union declined to recognize the Confederate States' right to secede and imposed on them laws passed by Congress during the period when the Southern representatives had withdrawn. Now, that was a dramatic assertion of the principle that the US Constitution had created a new political identity for its component states. By comparison, the European Union has now expressly accepted the right of member states to secede since the Lisbon Treaty, and implicitly, probably even before that. Now, there are some legal issues which cannot be resolved by legal analysis, because they depend on what jurists have sometimes called fundamental constitutional facts. If the EU asserts the primacy of its own law, and the member states assert the primacy of their own constitutions, and neither of them backs down, the conflict can only be resolved by a trial of political strength. It cannot be resolved by law. In other words, the outcome must ultimately depend on fundamental constitutional facts. The idea that EU law derives its force from a new pan-European constitutional order, displacing the legal order of member states in areas within its competence, can really only work if either the constitutional organs of member states accept it as a matter of their own domestic law, or else the organs of the European Union are able to enforce it by force and not just by law. The decision of the Polish Constitutional Court according legal primacy to the Polish Constitution is not unique. Far from it. The leading judicial champion of the primacy of national constitutions over European law is not Poland, but Germany. Now, I want to focus on the decisions of the German Constitutional Court, the Bundesverfassungsgericht. They are, I think, exceptionally important, partly because of the political and juridical weight of Germany in the European Union, and partly because of the very high quality and detailed reasoning of its judgments. The fact of the occasional conflict between the Bundesverfassungsgericht and the European Court of Justice is well known, but the details of the argument are not always known. In a series of decisions, the German Constitutional Court has subjected the domestic application of European law to certain constitutional conditions under German domestic law, of which it is itself the judge. These decisions are sometimes called the Solange decisions. Solange wie is the expression of conditionality in German. It means provided that. Germany has incorporated European law into its domestic legal order by its own basic law, the Grundgesetz. but only in qualified terms. Article 25 of the Grundgesetz provides that international law is an integral part of the domestic law of Germany and prevails over domestic statutes. Articles 23 and 24 empower the German legislature to transfer sovereign powers to a European Union that is, one, governed by the rule of law, two, subject to the principle of subsidiarity, and three, protects basic rights by its own provisions equivalent to those of the basic law itself. Now, these three things have been interpreted as conditions for the application of European law in any particular case. In addition, the Constitutional Court has recognized a number of implied conditions arising from the character and identity of the German state as the foundation of German civil society. In 1974, in Internationale Handelsgesellschaft, usually called Solange I, the Constitutional Court accepted in principle the primacy of European law. But it held that without a constitutional amendment, international obligations could not prevail over what it called, and I quote, the fundamental principles of the Constitution forming the basis of German identity. It followed, they said, that European law could not prevail over fundamental rights conferred by the German Constitution unless substantially equivalent rights were conferred by the law of the European Union itself. 12 years later, in 1986, the court retreated from that position in another case, Wünsche Handelsgesellschaft, sometimes called Solange II. It held that the recognition of human rights by the institutions of the EU and the creation of a directly elected parliament had reduced the scope for conflict. So while the court retained a right to review European legislation for conformity with the German constitution, it would in future refrain from exercising that power. As a result, the issue largely disappeared until it re-emerged with the considerable enhancement of the competences of European institutions. The main milestones of that process were monetary union following the Treaty of Maastricht and the enhancement of the legislative role of the European Parliament in the Treaty of Lisbon. In 1993, in Brunner, the Bundesverfassungsgericht heard a constitutional challenge to the Maastricht Treaty, and in particular to the transfer of monetary policy to the institutions of the European Union. The challenge failed, but the court developed a new principle under which it reserved to itself a right to review the powers conferred on Europe by the EU treaties and in appropriate cases to declare that the exercise of those powers by European institutions was ultra vires those institutions and ineffective in Germany. This was to be classified as a question of domestic law because it was under German domestic law that the powers had been conferred on the Union in the first place. European law, they declared, and I quote, can only have binding effects within German sovereign sphere by virtue of the German instruction that its law must be applied. Subsequently, the tone was set by the remarkable judgment of the Bundesverfassungsgericht on the Lisbon Treaty in 2009. This was a consultative opinion on the status of the treaty. It arose out of a constitutional challenge to the right of the German state to ratify it on the grounds that it restricted the legislative autonomy of Germany. Once again, the challenge failed, but in rejecting it, the court developed a wide-ranging concept of constitutional identity. It held that Germany could not transfer legislative powers which undermined, in a way which undermined either the constitutional identity of the German nation or its ultimate right of self-determination. That meant that it could not recognize any right of the European institutions to determine the extent of their own legal powers. They must always be subject to the limits of the powers conferred on Europe by national law. Those limits had to be determined as a matter of national law by national courts. The most interesting part of the court's remarkable analysis was the section in which it identified those things which were fundamental to Germany's existence as a sovereign state and were therefore not amenable to transfer to any supranational body. They were the areas of policy which, in the court's words, depended on cultural, historical, and linguistic perceptions. They included citizenship, control over the organs of force, i.e. the police and the armed forces, control of public revenue and expenditure, criminal law, education, family life, faith, and collective ideology, and more generally, those matters which shape the living conditions of citizens. It's a very, very broad agenda. The court pointed out that in spite of the growing integration of Europe, the public's political perceptions were still largely molded by national identities and national experiences, and by their own languages, history, and culture. In other words, democracy remained essentially national and not, or not yet, European. No other judicial decision in any country has explored the question of national identity and its legal implications in such depth. I suggested a few minutes ago that the conflict between European law and national constitutions could only be resolved by a trial of political strength, by some ultimate political fact, some ultimate constitutional fact. The decision sets out the ultimate constitutional facts in German eyes as clearly as any decision of which I am aware. Now, one of the factors listed in the Lisbon judgment as making up the German identity was the control of public revenue and expenditure. I doubt, for my part, whether many countries would have included that item, but its inclusion reflects one of the most powerful political instincts in modern German history, the fear of uncontrolled inflation of the kind which nearly ruined Germany in the 1920s, contributing to the political instability of the following years and to the rise of Nazism. Now, that was the unspoken fact which lay behind the series of decisions from 2012 onwards, in which the Bundesverfassungsgericht laid down limits on Germany's right to participate in the European Stability Mechanism and then in the European Central Bank's program of purchases of member states' public debt. The complaint against these measures was that they could potentially involve Germany in assuming obligations fixed by the European Central Bank or by the majority of participating states and not by purely German constitutional organs. The most recent and controversial of these judgments was given in May 2020 in the case of Weiss. Now, Weiss was a complex case which is not easy to analyze, but within the limits of permissible brevity, I will make this attempt to do so. The basic problem was that the European Central Bank had exclusive competence in the area of monetary policy in the Eurozone, but not in the closely analogous area of economic management. In 2015, the European Central Bank embarked upon a program of purchases of Greek public debt. The object, at least one of the objects, was to spread the risk of a Greek default across the national central banks of the Eurozone, including, of course, the Bundesbank. Mr. Weiss was one of 4 Eurosceptic politicians who complained in the Constitutional Court that the Bundesbank and the federal government ought to have opposed this program because it meant that a Greek default might require the Bundesbank to be recapitalized at the expense of the German taxpayer so as to meet defaulted Greek public bonds. Mr. Weiss's main argument was that viewed as purely monetary measures, the purchases were disproportionate because the monetary benefits were small and the risks very great. But he said they weren't really monetary measures at all. They were disguised exercises of powers of economic management, which the European Central Bank did not possess. The German Constitutional Court referred this question, among others, to the European Court. Luxembourg answered that the measures were properly to be classified as monetary measures and were proportionate. When the case returned to Karlsruhe, the court rejected that answer. The Bundesverfassungsgericht began by reiterating that control of financial autonomy and exclusive control of public revenue and expenditure were fundamental to Germany's constitutional identity. It then went on to hold that the European Central Bank's proportionality analysis was defective because it didn't take into account all the economic consequences of the debt purchases. The European Court of Justice's endorsement of the European Central Bank's proportionality analysis was said to be incomprehensible and therefore beyond the competence of the European Court of Justice. Unless and until the central bank did another proportionality analysis on the principles favored by the German Constitutional Court, that court could not conclude that the bank had acted within its competence either. Its decision would therefore have no legal effect in Germany. Now, Weiss is a most extreme decision. This is because the court's basic criticism of the European Court of Justice was that it got the proportionality test wrong. Even if it did, that error did not, on the face of it, go to the European Court's jurisdiction. The Court of Justice was undoubtedly competent to decide the issue. Why else would the Bundesverfassungsgericht have referred it to them? The European Court's just judgment, as far as I can see, was not ultra vires, simply because it got the answer wrong in the view of a national court. The logic of that position would be that every national court would be entitled to decline to receive European law as declared by the Luxembourg court on the ground that it disagreed. The legislation of the European Union would then have to comply with the analytical methods of every one of its 27 national systems as a condition of its recognition in their domestic legal order. Interestingly, the European Commission brought infringement proceedings against Germany. Constitutionally, the function of defending Germany fell to its government. The German government declined to defend the decision. The Commission then closed its proceedings last December on the grounds that it had received suitable assurances from the German government. Now, those assurances had to come from the government. Since the Constitutional Court is independent of the government, the very principle which the Commission has invoked against Poland, the acceptance of German government assurances looks very much to me like a political fudge. The Commission does not want to take on Germany. It would prefer to concentrate its power on weaker countries which are more heavily dependent on EU funds. The principle that there are inalienable powers fundamental to a state's constitutional identity, which cannot be undermined by EU law without a sufficiently specific constitutional amendment. That principle has been developed further by the German court than by any other. But it is in fact common to almost every national legal system which has considered it at all. The consensus of European domestic jurisprudence has been that European law prevails over ordinary domestic law, but not over national constitutions. Ironically, one of the most robust statements to this effect is due to the Polish Constitutional Court at a time well before any question arose about its judicial independence. In its consultative decision in May 2005 on Poland's original accession to the European Union, the Polish Constitutional Court declared that the Constitution of Poland was the supreme act expressing the nation's will, their words. European law could not therefore prevail over a constitutional norm or limit its application. Any conflict would have to be resolved either by a constitutional amendment or by leaving the European Union. Now, that is exactly the same principle as the Bundesverfassungsgericht declared 4 years later in its review of the Treaty of Lisbon. In Italy, the Constitutional Court reserved to itself as early as 1974 the right to question the application of EU law when it potentially infringed what the Constitutional Court of Italy called supreme constitutional principles of the Italian state. In the case of Frontini, it established that EU law did not prevail over fundamental principles of the Italian constitution or over the inalienable rights of Italian citizens. This was because Article 11 of the Constitution of Italy, which authorized limitations of sovereignty in the interests of world peace, was the basis on which the EU treaties had been approved in Italy, and that was confined to measures directed to world peace. France is another interesting example. France is a monist jurisdiction, i.e., it's a jurisdiction whose constitution directly incorporates its international obligations into domestic law. Nonetheless, the Constitutional Council has ruled, borrowing the language of the German Constitutional Court, that an EU directive could not require the state to legislate contrary to what it called the constitutional identity of France. But when the Constitutional Council came to review the Lisbon Treaty, it approved its ratification on the grounds that the Constitution of France made specific provision for the incorporation of such treaties into domestic law. But it warned that a constitutional amendment would be needed before France could recognize domestically any European measure that, quote, called into question constitutionally guaranteed rights and freedoms or adversely affected the fundamental conditions on which national sovereignty is exercised, unquote. The Constitutional Court of Spain has held, in reviewing the Treaty of Nice, that general provisions of the Constitution authorizing the application of European law domestically within Spain may not undermine the sovereignty of the state, its basic constitutional structures, or the fundamental principles and values on which it is based. In its own leading case, Crotty against Anne Tisach, the Supreme Court of Ireland tentatively held, in the course of a review of the Single European Act, that the transfer of any substantial aspect of the legislative or governmental sovereignty of the state of Ireland would be unconstitutional if enacted by ordinary legislation. It would require a constitutional provision or amendment. Similar declarations can be found in the constitutional jurisprudence of the Czech Republic, Denmark, Estonia, Latvia, and I dare say other jurisdictions which I have not been able to track down. It is perhaps surprising to find the United Kingdom in this distinguished company. The United Kingdom is the only European country which has no written constitution and therefore no body of fundamental law with which European law can ever be said to be inconsistent. When Britain first agreed to join what was then the European Economic Community, Mr. Blackburn, a prominent Eurosceptic campaigner, applied to the High Court for a declaration that the government had no power to surrender essential features of Britain's sovereignty to an international body. The court accepted that that would indeed be the consequence of joining the EEC, and they cited Costa and Enel. But Mr. Blackburn's claim was nonetheless struck out as unarguable. Yet his basic argument was exactly the same as the argument which has now been accepted in principle by most of the constitutional courts of Europe, they have implicitly rejected the more ambitious claims of the Luxembourg Court in Costa and Enel. The difference is that whereas the British Parliament has unlimited political and legislative sovereignty, every other European state operates under formal constitutions which limit the power even of the legislature in the absence of a constitutional amendment. Nonetheless, in the course of Britain's 47-year membership of the European Union, its courts were eventually forced to recognize some limitations on the primacy of European law when it conflicted with basic constitutional norms. They began to recognize a class of constitutional statutes which could not be repealed or amended by implication whenever a later statute was passed that was inconsistent with it. They could be repealed or amended only explicitly. One of these constitutional statutes was the European Communities Act 1972, which introduced European law into the domestic law of the United Kingdom. Now, the result of recognizing this body of constitutional statutes was, as a divisional court held in a case called Thoburn and Sunderland City Council in 1987, that European law applied in the United Kingdom only insofar as the European Communities Act 1972 allowed. Lord Justice Laws, who delivered the judgment of the court, pointed out that the application of EU law in the United Kingdom depended on its domestic law and not on EU law. It followed, as he went on to observe, and I quote, "In the event, which no doubt would never happen in the real world, that a European measure was seen to be repugnant to a fundamental or constitutional right guaranteed by the law of England, a question would arise whether the general words of the 1972 Act were sufficient to incorporate the measure and give it overriding effect in domestic law." Now, Lord Justice Laws was confident that it would never happen, but in fact it did happen in the real world. The environmental legislation of the European Union contains provisions which empower national legislatures to authorize environmentally sensitive projects, but require national courts to ensure that they only do it after proper scrutiny of the project. Now, that is uncontroversial in countries where the Constitutional Court can review acts of the legislature. But in the British constitutional order, it's anathema. Article 9 of the Bill of Rights of 1689, perhaps the ultimate British constitutional statute, provides that proceedings in Parliament are not to be questioned in any court of law. In HS2 Alliance against the Secretary of State for Transport, the Supreme Court of the United Kingdom was dealing with a judicial review of a decision to authorize a high-speed railway link between London and the Midlands. It found it possible to decide the case without reference to this issue, but it observed that if there is a conflict between a constitutional principle such as that embodied in Article 9 of the Bill of Rights and EU law, that conflict has to be resolved by our courts as an issue arising under the constitutional law of the United Kingdom. The relevant UK law was the European Communities Act 1972. The court thought that that act would not be sufficiently clear to authorize a violation of a fundamental feature of British constitutional law. Now, what the Supreme Court was doing was substantially the same as what the Bundesverfassungsgericht had been doing since 1974, namely to imply into British constitutional statutes limitations to protect the fundamentals of the Constitution. In Miller and the Secretary of State for exiting the European Union, one of the two cases in which the UK Supreme Court rebuffed the way in which the government proposed to leave the European Union, the Supreme Court observed that legislation which alters the domestic constitutional status of EU institutions or EU law is not constrained by the need to be consistent with EU law. In the case of such legislation, there is no question of EU law having primacy. so that such legislation will have domestic effect, even if it infringes EU law. Now, the conflict between EU law and national constitutions is where law and politics meet. It can be resolved by some ultimate constitutional fact, in effect, a trial of political strength, but only in that way. Now, this is a lecture about law and not about politics, so I don't wish to delve too far into the domestic politics of the United Kingdom. There is, however, an obvious connection between the idea of constitutional identity, which underlies the jurisprudence of so many national constitutional courts in Europe, and the sentiments which persuaded a narrow majority of the British electorate to vote to leave the European Union in 2016. Personally, I regret that decision. I think it was a serious mistake. But I have always tried to warn audiences in France and Germany, countries that I know well, against the facile view that this vote was due to the xenophobia, post-imperial nostalgia, or to lies written on the side of campaign buses or any other nonsense explanation like that. The British knew what they were doing, however misguided one may believe them to be. They did it out of a sense of national constitutional identity and fear of seeing that identity subordinated in a larger and more distant European polity. These feelings were not as carefully articulated as the judgments of the German and other constitutional courts, but they were just as powerful. As the German court has pointed out, there is as yet no European identity to supersede the national identities of member states, nothing to which the mass of European citizens can feel a common and overriding loyalty. And until there is one, the tensions which I have been discussing in this lecture will persist. Real conflicts, which cannot be resolved legally, will sooner or later have to be resolved politically. Thank you for listening to me.
Thank you, Lord Sumption, for that fascinating discourse, which has really given us a lot to think about. Before we move on to the next stage of the evening, I just want to say a few words of gratitude. I'd like to thank my colleague, Professor Una Breen, the Chief Justice, and Ms. Justice Niamh Howlin for their involvement in ensuring the continuity of this lecture series. I'd also like to thank my colleague, Una Kelly, the Marketing and Events Manager, and her team for putting together such a lovely event after we're a little bit out of practice having visitors in. So we hope you can bear with us. Thank you all for coming to the School of Law this evening. And I hope you'll be able to join us for some refreshments in the atrium after this. I think there's probably a lot of conversation I think we can continue out there. And finally, can we just once again show our appreciation for our speaker, Lord Sumption, with one final round of applause for the evening.